A topic we have spoken about quite a bit is the notion of sensitive places, which is a euphemism for government-mandated gun-free zones. And we've talked about how, although the Supreme Court has made passing references that some concept of sensitive places is consistent with the Second Amendment, it's not that broad. A powerful presentation was made by David Thompson of the law firm of Cooper and Kirk, whose law firm is handling something in the order of magnitude of over 60 Second Amendment related cases in America right here and right now. I want you to check out how he explains how to understand the notion of quote-unquote sensitive places, which again are government-mandated gun-free zones, and when might they be constitutional under the Second Amendment, if ever. Right here, right now, let's turn to the presentation to the Federalist Society by David Thompson on the notion of sensitive places and our Second Amendment.
Now let's talk about another topic, where you can carry a gun. And as you all know, Bruen said 2 years ago, there's an individual right to carry a firearm. But the court also indicated there were certain sensitive places that were off limits to carriage. They listed 3 places: courthouses, legislatures, and polling places. And so a number of blue jurisdictions have swept in after Bruen and have said, even though we allowed guns in these places previously, now, they're super sensitive. Cities are super sensitive, Parkland is super sensitive, state parks are super sensitive, basically trying to paint their entire jurisdiction with these sensitive place brush. The Ninth Circuit just decided an important sensitive place case called Wolford versus Lopez. And it involved laws in Hawaii and California that had declared a myriad of places to be sensitive. And after wading through and trying to compare each place with the 3 places identified in Bruen, the Ninth Circuit declared that guns could be banned in some places like stadiums and museums, but not other places like hospitals and public transportation. And then, interestingly, the Ninth Circuit concluded firearms could be presumptively banned in businesses in Hawaii, but not California. And the Ninth Circuit worried that its opinion was arbitrary. You think? When you're at the point, I wouldn't ever presume to tell a judge how to do their job, but when you're at the point where you're writing, gee, this opinion seems really arbitrary, that might be a time to go back and re-examine. And if they had, one of the flaws for the Ninth Circuit was it did not even attempt to derive a historic principle from the analogs that it has found. And it's little wonder that having failed to actually try to implement the Bruen methodology, it failed spectacularly. Now, the Ninth Circuit isn't alone. The Second Circuit has recently held that vulnerable communities can be treated as gun-free zones. And you're right to ask, how did they derive that principle from the analogs? Were legislatures vulnerable communities? No. Were courthouses vulnerable communities? No. The Second Circuit just made it up, and they didn't engage in the cross-checks. They didn't look to see if there's a third rail they were touching. If they had, they wouldn't have been, there wouldn't have been a principle that would have said, let's take people who are vulnerable, strip them of their ability to defend themselves, and paint a target on them. Did the founders do that? No, the founders did the exact opposite of that. At the time of the founding, there were many state laws that said when you go to church, you must carry a gun. Why? Because everyone was at church, so the community was really vulnerable. And so that is this vulnerable community test simply doesn't work. Another test that anti-gun advocates are pushing is, well, the common theme in all these places is the exercise of constitutional rights. So whenever constitutional rights are if you're in a place where constitutional rights are being exercised, that's a sensitive place. Breathing is a constitutional right. Speaking is a constitutional right. So any place where you're speaking, you're breathing, that can be a sensitive place. Obviously, that's not going to work. It would eviscerate the Second Amendment. So what are the courts to do? They should look at the history surrounding courthouses, legislatures, and polling places. Now, I know that at least one Supreme Court justice has lamented this would be, quote, exceedingly difficult. But if we talk about 13 colonies in 3 places, that's 39 maximum statutes divided by 4 law clerks. It's like less than 10 statutes per law clerk. So I say suck it up and do your job. And, if the courts were to do this, they'd see an interesting theme in these up to 39 statutes. They'd see in virtually every courthouse in America at the time of the founding, there was armed security. And they would see that in virtually every legislature at the time of the founding, there was armed security. And at polling places at the time of the founding, there was armed security. The common theme behind all of these laws is comprehensive security. And it makes sense. When the government provides comprehensive security, there is less of a need for self-defense. So the historic principle is fully consistent with one of the primary purposes of the Second Amendment, self-defense. That's why when you go through TSA and they have metal detectors and armed guards, that you feel less vulnerable on the other side. Now you may say, well, I wore my MAGA hat and was attacked by some Karen. That's an as-applied challenge. That's an as-applied challenge. It's not a facial challenge to TSA. And if we, and parks under this would not be sensitive places because you can't secure the egress and ingress. Take a hospital. It could be a sensitive place or not. If the government wants to invest the resources to have every entrance have a metal detector and armed guards, then it's a sensitive place. And if not, not. Now, Heller, I want to say one thing in closing. Heller mentioned schools. Bruen did not. But it is important to know that at the time of the founding, there were lots of restrictions on guns in schools. Harvard in 1655 was the first school to limit guns in schools, and pretty much every college in the country followed suit. But one thing to note, it was only for students. It was never for teachers. There is no historical justification for disarming teachers, and the students could have their Second Amendment rights infringed upon because the schools were in loco parentis. And so they were very differently situated than at least most schools today. I don't think they're in loco parentis. The bottom line is that there is no shortcut for doing the hard historical work. Judges have to look at the statutes. They need to look at the how and the why behind the analogs. And they need to make sure that whatever principle they derive is fully consistent with each of the guardrails that Mark has identified today. And if the principle touches on any of the guardrails, it's dead, and they need to start over and begin again. Justice Scalia really did say it best in Heller. He said, the very enumeration of the right takes it out of the hands of government, even the third branch, the power to decide on a case-by-case basis whether the right is really worth insisting on. Justice Scalia nailed it. Thank you.
Orders up. Table 2A.